Good afternoon. I'm attorney Robert Broadie of Carolina Legal Solutions, and I want to again thank you for joining us for another episode of Testimonial Tuesdays. We want to encourage you to submit your questions on our Facebook page or online at www.carolinalegalsolutions.com. Our question today comes from a young lady by the name of Lee, and her question is as follows. My partner and I have decided that it will be better for us to come to an agreement outside of court. We have a 16-month-old, and I'm due in September with our second. What do we need to do once we have an agreement on paper to make it a legally binding agreement? Well, Lee, that's a very good question, and from your question, I take that you and your partner are not married. Particularly when two individuals share a child in common, and there's no wedding or there's no nuptials involved, there's a misconception that one person has primary custody or physical custody of the child, and that being the mother. That is a common misconception that's made a lot, and your question gives me a good cause to believe that you understand that there does need to be a legally binding agreement to determine who has primary custody of this child. So with that in mind, I want to encourage you to first always seek legal counsel when you're trying to do something that's going to be a legally binding agreement between two parties. In many counties here in North Carolina, there are what we call do-it-yourself packets at the county clerk's office that would allow you assistance in doing divorces, custody agreements, and things of that nature. So when you're looking to do that, you will have the opportunity to do it yourself. But to answer your question specifically, in order to have a legally binding custody agreement, there's actually going to have to be a lawsuit. Now, I know that sounds adversarial, and it seems that you and your partner want to do this in the joint and mutual way, but not all lawsuits have to be adversarial. There can be what we call friendly lawsuits. And what this lawsuit would do is one person will actually sue the other for physical custody or physical primary custody of this child. And once that lawsuit is in place, then it becomes docketed. Okay, and there will be a court date or a preliminary court date where you and your partner can go to court and advise the judge that you have mutually come to an agreement called a consent order. And you can submit that consent order for the judge to sign, and that is what actually makes it a legally binding document. So, in your situation, you may file a lawsuit claiming that you want primary physical custody of your children. You will serve your partner with that lawsuit. Once your partner is served, they will have an opportunity to answer or not answer. And once that period is expired, you or your partner can file a document to have that court case calendared in our district courts. Once the case is calendared, you will then submit your agreement to the judge for the judge's signature as a consent order. So that is the only way that you can have a document that two people have mutually agreed to sign become a legal binding document. Lee, we ask you to continue to submit your questions. We thank you for that question. For all others who are listening, we encourage you to submit your questions at carolinalegalsolutions.com or on our Facebook page. Also, you can always reach us at 885-1LAW. Thank you for listening, and we'll see you next week.